So as I said, I already mentioned this, the first slide, European Union Intellectual Property Office, project on Africa and IP that is called AfriP. What is it, AfriP? AfriP, basically, it's a big project funded by the European Union to support IP and innovation in Africa, and it develops on several components, as you can see in this slide. Of course, today we're going to focus on support to SMEs. That is the component of the project that I manage. Basically, what is an SME? For us, an SME is basically this. It's a company who has less than 250 staff, 50 million euro in turnover, or 43 million euros balance sheet, and it has to be an individual firm. So this is basically what we consider an SME in general in Europe, but also in Africa. And why is it so important for us, intellectual property for SMEs? So basically, I can give you some figures that I think are very relevant. So you see that, for example, already 90% of businesses operating in sub-Saharan Africa are small and medium companies. So it's really the big majority of the businesses operating in the continent. They contribute to 50% of the total GDP of sub-Saharan Africa. These two data come from the World Economic Forum sources. So, and then if I take a specific example of a big country in Africa, for example, Nigeria, we can see that 70% of Nigerian SME lack of any form of IP protection. This is according to the World Intellectual Property Organization. And then there are also positive note that SMEs with registered IP rights generate up to 68% more revenue per employee. And this is a source by our organization, UIPO, that made a study together with the European Patent Office. So that is the reason why we are really pushing SMEs to become more and more aware about the importance of intellectual property for their long-term success. This is a slide to show you where we operate. I mean, we're talking about Africa today, but there are also other projects. The European Union funds many projects around the world, and many of these help desks operate in several regions around the globe. So Latin America, Europe, India, China, Southeast Asia, and of course, Africa, that is the continent we are focusing today. This is just a screenshot of our website. We operate on online. So here you will find all the information that I'm going to describe in my presentation right now. So let's get into the details of what we do. This project consists of providing free of charge services to SMEs. And these services are basically three. The first one is a helpline that consists in receiving requests and questions and queries from SMEs and stakeholders interested in IP in Africa. And we provide answers for free. We advise for free. Then we have the website that I've already mentioned, where we upload many intellectual property materials that are also available and can be downloaded for free. And we organize events and training sessions like the one we are giving today in collaboration with AfriLabs. But now I want to get into the details of each of these services to ensure that you have an idea of what you can ask us and what we can provide you with. The first one is the helpline. So the helpline, as I said, is basically a support service that is available to all SMEs. You can just contact us in several ways. You can either send an email or call or chat, and we answer within 3 working days. We operate in 5 working languages that are English, of course, but we do also operate in French, Spanish, German, and Italian. What we can offer through the helpline, so it's a confidential, personal service. We can evaluate your company, let's say, try to help you build a business strategy that includes intellectual property. For example, if you should focus on registering a trademark, or if you should focus on copyright, or if you should focus on patents. And we provide also good practices. We give you some practical tips on what you should do, what you should avoid. One remark is that we do not provide legal support service, meaning that we cannot represent you in front of an IP office. If you're going to file your trademark, we cannot do this for you. But we can advise. We can tell you what is the best way for you to register your IP right, and provides any other tips that can be useful to facilitate your IP journey. These are the kind of requests, the most received queries. The first is, of course, cross-IP, because they are not specifically about any IP rights. They can be just, I want to protect my IP. I'm a new company. What should I do? Should I start with a trademark? Should I register my patent? So this is the kind of cross-IP, and it's majority of question, because what we can see from by talking to companies is that there is lack of awareness. So sometimes people, they just need advice on what they should do. Then, of course, the most requested query is about trademarks, and again, enforceability. So, okay, I registered my IP rights. Now, how can I make sure that I'm safely protected and no one is stealing my rights or infringing my rights? Then, if I have to mention the second service, the so-called online resources, this is what we can offer. We have a broad range of country fact sheets that are published on our website. We have one country fact sheet per African country. So 54 countries plus 2 big IP organizations, ARIPO and OAPI, that Mr. Kone will describe later in his presentation. These country fact sheets, they describe the IP systems of the whole African continent, and they are available for free. So you can browse our website, you can scan the QR code and go straight to the webpage where you can download these documents. Apart from these fact sheets that are very general to give an overview of the IP system, we have more specific documents, such as the IP guides that are more specific and go, for example, into the details of, I don't know, patent validation in Tunisia, for example, or Angola manufacturing sector and IP. And also we have case studies that real examples of cases from companies that are operating in Africa and what they did in specific circumstances when they faced some challenges, how they overcome the problem, and so on. And of course, we have training modules that are basically webinars that are recorded like the one that we are delivering today, and that are available again on our website for free. These are just numbers to give you the idea of what we can offer. There are many, many materials, so I truly advise you to go on the website and exploit these materials as much as you can. And these are like the layout of what we can offer: case studies, IP guides. They are written in a very simple way so that companies that are reading them can understand what's in it, because sometimes IP can be very technical, but these are written in a way that you can understand that. And then the third and last service that we can offer are the organization of training and events. We have both online events like the one we're having today, on-site seminars, capacity building. We participate in matchmaking events. We collaborate with local experts and stakeholders like AfriLabs. And we help connecting SMEs with multipliers. So it's marked in red because I know there are also some business support organization today and members of hubs that can be wondering why they are attending this webinar and why it is important for them. So we are there for you, because you can, if you want to organize a training in the future, you can contact us. We can provide this training for free. We can organize a tailor session if you work for a company, for example, on innovation and artificial intelligence. We can organize a dedicated session on this matter and this relation with IP. So feel free to get in contact with us, because these services are for free. You can see here the outreach. We are very active, and we are really looking forward to hearing from you. Here are the contacts. I think I'm going to share them in the chat as well, so you can, apart from scanning the QR code, also get in touch with us. And I will just stop here my presentation and leave the questions and answers to the end so that I can give the floor to my colleague, Mr. Kone, who will be now going to the technical details of IP and Africa. So thank you very much for your time. And Mr. Kone, please, the floor is yours. Thank you.
Thank you very much, Mr. Hiyori. Thank you for having been able to respect the time limit. Thank you for that. So I'm Mr. Amidou Kone. I work with AfriP as IP enforcement expert. So I have to talk with you today about intellectual property. I myself, before joining AfriP, I've been working with OAPI, one of these two big organizations in Africa, and Mr. Hiyori told of this right now. And without losing too much time, I'll start sharing my presentation with you, and I hope you are all understanding quite well what I'm saying. So just a minute to share my presentation. And the first slide is, you have here my name, Amidou Kone, IP expert at AfriP. So this morning, we'll have to talk about an overview of IP system in Africa and at least one case study. We would like to have more case studies, but we have just 1 hour, and in 1 hour you cannot talk too much. But if we have time after this presentation, maybe we can add other case studies. I want to pass to presentation modes. Okay, now my presentation will focus around these elements. First, SMEs and IP protection. My colleague Yori talked a bit about IP and SMEs, and he defined what is an SMEs in the conception of EU IPO. And after then, we'll see the two big organizations in Africa, ARIPO system and OAPI system. I'll have to talk about these two organizations to you because you will need to have protection on these spaces, on these regions. And then we'll pass to a short comparison between the two systems. And after that, we'll have an IP protection panorama of certain countries in Africa, like Nigeria, where most of the attenders are from now, and Ghana. And after we'll see Morocco and Egypt and South Africa. When we were in the beginning of this session, I heard that some of you are from South Africa. And then we'll see the case study, Baramuso, which is a case where I talk how to use intellectual property in the growth phase. And after, I'll speak about some smart IP strategies, and we'll finish by some conclusions and lessons learned throughout this presentation this morning. The link between SMEs and intellectual property. An SME activity can be considered as two big elements. The first one is production of goods, and the second, services. These are the main group that compose the activity of SMEs. And when you are in this field, production of goods or services, you are going to create technologies to draft works and to have shapes for your product. Can't you see my screen?
No, we can see your screen. Yeah, we can see your screen.
So you'll have words, shapes, and designations of your products. These are the elements that will always be in your activity. And for this, you'll have security matters to protect all this. And to protect this, you'll have then to go to IP protection. IP protection meaning patents, trademarks, and designs. This is the link between SMEs and intellectual property. You will see that we have talked about IP. What is IP itself? Intellectual property is this branch of law which deals with creations of minds. As such, it represents the right to tangible assets, meaning creations of mind. Every time you create something, you have the right to protect it for yourself. And this branch of law is divided into two main branches. The first one is industrial property, which includes patents, meaning protection of inventions and technical innovations, trademarks, meaning the sign you put on your product to be able to sell them and so that people can recognize your product. These are called trademark that is a protection of symbol, names, and slogan for identification of your goods and services. You have also industrial design that protect the aesthetic aspects of your product, such as shape, pattern, or colors. Where every time you have a product, you should have in mind that the better the product will be beautiful, the easier it will be to sell it. That's why this asset of industrial property has been created. And we have also in the industrial property what we call geographical indications, protections of name or signs used on a product that have a specific geographical origin and possess qualities and or reputation due to that origins. And mostly we'll find these products in agricultural products. But the creation of the name geographical indication is a way to broaden this conception. Before it was called appellations of origin. And this appellation of origin was created to protect agricultural products. But now, due to a kind of evolution of intellectual property and standardizations of concepts, the expression geographical indication has been created to include also the handicrafts products. One more, we have in industrial property what you call trade secrets, which is the protection of confidential business information that provide competitive edge. Now the second branch is the literary and artistic property. It includes copyrights. Copyright is the protection of works such as books, music, painting, culture, films, software, etc. Copyright protects your creation in the literary domain and artistic domain. You have also what we call related rights, which is the protection of right of performance, producers of phonogram and videogram, and broadcasting organization. This is the second branch of intellectual property. But when speaking intellectual property, whatever the size of your company is, whatever the sector of activity, it's about leveraging IP assets. It's about helping to safeguard your innovation and maintaining a competitive advantage in the market. It's about increasing your product profits. It's not just only words to talk about something which you don't know. It has a practical benefit. It has a practical use. And IP can help you then protecting your inventions by patent and utility markets, branding your products by trademark, When you have a very good product, you go with it to the market. People need to know how we can get this product, and for that you need to brand your product, to have a trademark. And after that, protecting your designs and model. I was talking about the beauty of your product. You can protect that by industrial designs and models. Protecting your literary and artistic work by copyright and related. Then we have talked a lot about IP. As entrepreneur or investors, you may say, Mr. Kone is talking about IP. Where can I have this protection? IP is organized in the world at 3 levels, which leads to 3 groups. The first level is the international level. This international level is managed by WIPO, World Intellectual Property Organization. And we have a regional level where we have some countries that have put together their means to have only one intellectual property organization. And in this, you have EUIPO, where Mr. Yuri works. You have EPO. EUIPO deals mostly with trademarks and the distinctive sign, I can say. And EUIPO deals in Europe with patents. It's the European Patent Organization. And WAPI is the African Organization for Intellectual Property, WAPI. And it deals with all these matters. We'll see that later on. And at this regional level, you have also ARIPO, African Regional Intellectual Property Organization. And thirdly, you have at the 3rd level, what we call a national level. Individual countries have their own intellectual property office. Now we'll talk about these 2 organizations. We have the first one, which is ARIPO, and the second one, WAPI. I won't last too much time on these things because you will have my presentation. I just summarized their presentation. ARIPO is established. It has been established in 1976, and it gathers 22 African countries. And the IP matters protected goes from patent, utility models, industrial design, to technology, to traditional knowledge and geographical indications, and other new plant varieties and copyrights. This is its charts. Organization charts, and these are the 22 countries lists. You can find this in my presentation. And the characteristic of this system, the legal basis of IPR grant or registration system. We have a certain number of protocols which deals with the different IP titles, like Harare Protocol with patent utility model, Banjul Protocol for trademark, and so on. You have this presentation. Other characteristic of this system, the IPR granted are only valid in the member state party to the relevant protocol, and state can be designated in the application in the ARIPO system. Then you can have also national right and regional right in the IP system. The way of examination is substantive examination, and the title granted are published in their official industrial property bulletin. For the finance, they finance themselves with the fees paid to protect your IP titles. Where to file directly to the organization or through the industrial property office. But this is for nationals. But for people outside this region, they have to require the service of an attorney, or what we can call a representative agent. How to file? We can have in this system e-filing, email to Aripo, courier, or in-person fees are applicable. You can find their fees on their website. Now we come to ORP. You have to manage time. ORP has been established in 1962 under the name of ORP, African and Malagash Organization Industrial Property Office. And now it has become an organization without Madagascar. That's why it has the name OAP. It's an intergovernmental organization gathering 17 African countries, and the IP matters protected go from patents to copyrights, passing by trademarks, new plant varieties, geographical indications. But when talking about copyright, it's not directly protected at the organization. We have national structures dealing with that matter we call CMOs. This is the chart of the organization chart of WAPI and the member state, the 17 member states. The basis legal, you have what we call the banking agreement, which has two parts, the body of the agreement and the annexes, in 10 annexes, each of them dealing with one IP element. All these organizations are parties to international agreements. Coming to the case of OAPI, it's a common office, which is called OAPI, and the title granted or registered, the IPR granted or registered, just one. When you apply for these 17 countries, you send your application to OAPI, and you will have just one title granted, which is valid in the 17 countries. In this system, you don't need designation. You just have to apply to OAPI, and automatically you are protected in the 17 countries. There is no national system issuing a title in coexistence with the regional system. What else? It's a unitary system with substantive examination also. Since 2 years now, substantive examination has been started for a distinctive sign, and only this year, 2025, substantive examination started for patents and utility models. Finance, they finance themselves by the fees you pay for protection of your IP rights. But in the ARIPO system, in additional to the fees you pay, there are fees paid by the member state also to finance the organization. But there is no fees paid by the member state in the OAP system. Where to file directly to the organization or through a representative when you are not a resident of the region. How to file electronic transfer of data, which is a bit different from e-filing, but they are managing to go toward e-filing. You have also courier to OAPI or in person. Fees are applied, and you can find all these fees in the website of OAPI. Comparisons, the main element I talk about in this system is that ARIPO is a mixed system, or where OAPI is a unitary system. In ARIPO, you have coexistence of regional and national offices, but in OAPI, there is no national office. And there is a coexistence of international agreements and regional protocols in both of the two regions. And for applications, you can file international application or regional application. And in the case of ARIPO, you can file also a national application. the opposition to your registration lasts 3 months in each of the system. And the other element you can find in my presentation to summarize. Then let's go to certain African countries like Nigeria, Ghana, Morocco, Egypt, and South Africa. You can see in this map, in this, you can see in this picture, Ghana and Nigeria on this map. Nigeria has a national office. Ghana has also a national office, but is part of the ARIPO system, while Nigeria is not part of the ARIPO system. And they all protect trademarks, patents, and all these intellectual property subject matters. They are also parties to the main convention allowing the nationals to file international applications like patent, trademarks, and so on. Nigeria protects from patent to plant varieties, and the system of plant varieties protection is very new. We have an activity recently in Abidjan. We had the representative of this structure from Nigeria with us there on plant varieties. Ghana protects trademark, industrial designs, patents, copyrights, and fair competitions. Where we can file at an international level or national level for Nigeria. But for Ghana, you have 3 ways to file your application: international level, regional level, and national level. Opposition periods are 2 months for both of countries. And you have a way to do an appeal in case you don't trust the decision delivered by the office. And now we are in Morocco and Egypt on this map. Morocco has its national office and is not part of a regional organization, as we know. Egypt also has a national office. They are all parties to Paris Convention, Madrid system, and they have their national laws. And you know, when a country is party to Madrid system, it means that in this country, they can file trademarks at the international level, and by this route also, the ones who are out of these 2 countries can file also the trademarks in these countries through the Madrid system. Morocco protects patents, trademarks, and we won't take too much for this. This element we can find in my presentation. We have South Africa. We have the same element also for South Africa, a national office and part of international conventions, and protect from the patents to all the other element of intellectual property like trademark designs and copyrights. Each of these elements have their own acts in the South African system. Now, the IP matters protected include the secret, the trade secret, also the know-how and plant breeders' rights, adding to all the elements, like patent trademarks. You can, as I said now, make an international filing and a national filing opposition period, 3 months. And this is a summary of the IP landscape in some African countries and at the 2 main organizations. Now we come to the case study. In this case study, I'll have to talk about one private enterprise, which is a small enterprise. And just to let you know how to use intellectual property in the growth phase. When you are a small company, you are starting and you are growing, what you should know, what you should do, and what you should avoid. That's what we'll see right now. But about Baramsu, officially registered as Société Aminata Konaté, this company is a successful company in Mali, founded in 2008. The company is specialized in transforming local agricultural products into various food items such as condiments, spices, and cereals. Today, it's one of Mali's leading agro-industry. The founder is an individual whose name is Burema Dunya, a self-made entrepreneur who started this company with less than 500,000 CFA, meaning less than 1,000 euro, by selling just transforming local cereals. And someone who start with less than 1,000 euros, and you will see that Baramso reached over 45 products and sells in billions of francs CFA. The mission of the company is to alleviate the burden of product preparation for women and promote the consumption of locally produced food products. More than 80% of the staff are women. IP portfolio from 2012 to now, more than 30 trademarks, few patents, less than 10 names and designs. This company has already known at least the importance to go into IP, intellectual property. What was the strategy of the company? From 2012 to 2020, it was a very weak intellectual property strategy. But from 2020 to now, the company started training young employees in IP skills at the WAPI Academy, hiring IP experts to implement a strong IP strategy. But now what was the weakness? The weakness before 2020, a lack of a structured IP portfolio, leading to delay in renewing trademarks and names and designs. If you don't have a well-known portfolio, it just depends on your mind. I have one trademark I've registered at WAPI, but when? We don't know. And when we decide to renew this trademark, it may be late because you went out of the 10 years of validity of the trademark. Although a few trademarks were registered, they were descriptive, the quality of your trademark. The lack of IP expert assistant leading to opposition to trademark registration. This was their case. Since they didn't have an IP expert, they just see an image, it's beautiful, it's well known, they take it and they go to register it. And now they face opposition. They lose their money because it has been already paid at the organization. This money is not paid back anymore, and it's a failure. Lack of IP protection for products, composition, and manufacturing process. They didn't have any idea to have a patent. This was one of the weaknesses. They know what is a patent, but they don't know where to find someone to draft a patent specification, how to file at the organization. This was a problem. And so this technology, all this technical knowledge was in the mind of the technical staff. And this is a risk. What's the risk? It's the unfair competition. And they faced that. I'm not just supposing, but it was a reality. one of the best agents who knew all the system, marketing system, technology of protection has gone away due to unfair competition to another one, and dismissal when a staff is not happy with his salary, he can decide to dismiss. He knows all your technology, he goodbye, and you lose him and your technology also. So, IP smart strategy, is it a game or a real strategy? Dice or strategy? Obviously, it's a strategy and a strong strategy. What does it involve then? Think, plan, and manage. These are the keywords. Let's go on. Smart search first before you file. If you face opposition, this means that you didn't conduct a smart search. If you conduct a smart search, your IP rights go through the IP system, meaning the office, the organization, and the title comes to your office. You have your right without opposition. This is the importance of a smart search. Designation, state and classes when talking about trademarks. You have to designate carefully the state where your business will be and the class you are using. Some of you knows what's a class, but maybe some don't know. But in the trademarks field, products and services are classified according to the NIS classification. And this classification divides into 45 classes all the goods and services, where you have 34 classes for goods and 11 classes for services. You have to choose exactly the class of your activity to avoid some problems later. Now, when it comes to designate a state, depending on your means, choose wherever your product or service will be available. I say it again, wherever your product or service will be available, protect yourself there and choose the classes, the adequate classes. When more than 50% of your activity concerns one class, protect this class first. And you can add additional classes if your activity covers these classes. You have to use tailored class designation for state if necessary. In a country, you can have a product which is appreciated, very appreciated, but different from another country where you have another product. Then when you protect yourself in these two different countries, you have to protect the classes which are well appreciated in these countries. But in the OAPI system, for example, you don't need this. But in the ARIPO system, you need this. When you go to other offices, national offices, you have to think, as I'm saying. And then I told you that in some cases, if you are not in a region, you need to file through an agent, an IP lawyer. And for these two organizations, they have on their websites the list of accredited agents in the IP system. For ARIPO, you have the link on the website where you can find the list of agents, and it's the same for OAPI. You need this to avoid dealing with fly-by-night agents. Really, because if you take like that, you can take someone which is not an IP expert, it will take your money and do nothing. We have seen all that kind of behavior at OAPI. What are the lessons and the lessons learned and conclusion? IP should be a forethought, not an afterthought. It should be viewed as a set of tools for a commercialization strategy. Patent and trademark are only two forms of IP rights. Many others are applicable, like a trade secret, for example. They are less expensive, relatively. When I say less expensive, you can to hide a formula like Coca-Cola without making an advertisement. You need to. It involves a high means to hide a secret like that. But it's also a way where you don't pay annual fees also. Then consider IP rights that can benefit your business. Patent protects first before commercialization. It retains your novelty. But consider trade secret, as I said now, and choose this a strong distinctive sign. If you have a strong trademark, you can't face an opposition. Conduct search to avoid conflicting rights. Get professional advice. This is important. Prioritize IP awareness and education. This is a conclusion or a lesson when thinking to states and building institutional support for local innovators. This is also a duty of states to encourage public and private partnership for broader reach of IPS. These are the responsibility for OIP and structures like us, AfriP, for example, value gender diversity and promote women innovators. This is also something internationally promoted. This is what I had to talk with you this morning. Thank you very much for your attention.